So today I want to start with a hypothetical for you all, if I may. I want you all to imagine that you've been accused of a crime. Now, this could be vandalism, theft, nothing too serious. I want you to imagine you being taken into the local magistrate's court as you stand before the magistrate as they impose a criminal sentence upon you. Now, this could lead to a fine, a community order, maybe even 6 months in prison. Now, how many of you in that situation would be surprised to learn that the magistrate who has just imposed this criminal sentence has no academic law degree and has never even been to university to study law? By a quick show of hands. Quite a few of you, and it's understandable because it surprised me as well. But magistrates, or as they are better known historically, justices of the peace, are not and have never been required to have a law degree, despite them overseeing the local courts for centuries. Today, I'm going to go through a brief history of these justices of the peace. I'm going to highlight many of the challenges that they have faced, mainly around legal education, and explain to you why, despite this, they've remained an important part of the legal process to this day. So justices of the peace were established in 1195 as keepers of the peace. They were wealthy local landowners given powers to keep the peace in the counties against rebellion and rioting. However, that duty of keeping the peace was said to encompass a number of other duties, the most important of which was dealing with crime that threatened the peace. Thus, they were given additional powers to collect evidence and testimony, to arrest criminals, and to ensure those criminals attended court sessions, held 4 times a year, where the magistrates would rule and sit upon the cases before them. Now, this is very similar to the role modern-day magistrates play in the legal process. They are able to deal with a lot of less severe crimes which would otherwise clog up the legal process. Yet, they've also changed in many ways. I mean, we no longer expect magistrates to be on the streets arresting criminals themselves. However, despite how important they have been for centuries, the image which has survived of JPs in popular culture and in historical studies has been overwhelmingly negative. JPs have been characterized as lazy, as greedy, as corrupt, and most importantly for today, incompetent, uneducated, and ignorant of the law. This is because many JPs at the time, and still to this day, lacked a legal education. Now, I'm sure we've all heard of William Shakespeare, yes? Well, he included a JP in his plays. Robert Shallow JP appears in both Henry IV Part 2 and The Merry Wives of Windsor. Shallow is characterized as an elderly, vain, and deluded character, a man whose name itself, Shallow, is supposed to evoke ideas of arrogance from his aristocratic position and a lack of substance, being unlearned in the law. Now, this portrayal of Shallow is likely inspired by Shakespeare's own dealings with the then infamously corrupt London JPs. It is also likely inspired by the fact that Shakespeare wrote for a general audience, whereas the JPs were the killjoys. They were the ones who closed illegal alehouses, who sentenced people to death for theft, and who collected taxes. Never a very popular occupation. Yet, modern-day portrayals of JPs have been just as negative. The author C.J. Sampson, in his brilliant novel Disillusion, which recently received a Disney adaptation called Shardlake, included Gilbert Coppinger, a JP of Scansey. Coppinger is an even more negative portrayal than Shallow. He is utterly corrupt and moralless. His only interests are in making money. Justice be damned. Now, this portrayal of Coppinger, and in Sampson's later books, his dismissing of JPs as useless and incompetent, is likely inspired by his idolization of Thomas Cromwell. Cromwell was Henry VIII's principal secretary and Lord Chancellor, and he disliked JPs because they were men chosen for their wealth, not their qualifications. Now, this is understandable from Cromwell's perspective. He was the son of a butcher, who then went to university, became a lawyer, and then rose to high office. Whereas many JPs had never been to university whatsoever. They were chosen simply because of their wealth. Now, thankfully, times have changed since Cromwell's time. No longer do we give people positions of power simply because their parents were wealthy. Modern-day JPs are volunteers. They are chosen for traits of intelligence, integrity, and fairness. And they undergo a strict selection process and intensive training before they are allowed to impose criminal sentences. Yet, as we've seen with popular culture, the image that has survived of them is of an uneducated and corrupt group. You need to ask yourself, should someone without a degree in the law be able to impose criminal sentences? Are they knowledgeable enough about the law to be able to decide what is a fair sentence? It's a question that has been debatable for centuries. Yet, would it then change your mind if I was to then tell you that modern-day JPs, or magistrates, are advised by justices' clerks? These are trained lawyers who sit alongside the JPs and advise them on the law. Is it, therefore, necessary that every JP themselves be legally educated if they have always a trained lawyer there advising them, and they have gone through the intensive training which is designed to explain to them the powers, the duties, and responsibilities of their office? Now, historically at least, it was desired that some JPs be learned in the law. This was a desire expressed by Elizabeth I. Yet, in her first commission of the peace in 1562, only around a third of JPs, depending on the county, were formally educated, having attended a university or an Inn of Court which specifically taught the law. Furthermore, out of the roughly 28 JPs in Nottinghamshire and Derbyshire, the two counties that I study, only 2 or 3 at most were ever trained lawyers. Yet, those trained lawyers were required to be present whenever an investigation took place or an arrest was made, very much like the modern-day justices' clerks. But this highlighted a serious problem with the justice of the peace. Under the Tudors, the JPs were given increasing responsibility over a vast swathe of very diverse issues. This was everything from the poor laws to collecting taxes, witchcraft to religious nonconformity, building and maintaining bridges and sewers, even raising and training soldiers for war. With only about a third of JPs being educated, and only 2 or 3 trained lawyers per county who had to be present whenever anything important took place, the office of JP was stretched thin. Thus, under Elizabeth, there were many reforms to try and professionalise the office. First, the number of JPs was increased notably. Originally, in 1327, there were just 6 JPs in Nottinghamshire and Derbyshire. This had increased to around 28 by the start of Elizabeth's reign in 1562, and by the end of her reign in 1603, it had increased to over 40. Plus, the proportion of JPs who were formally educated increased. From that original third at the start of her reign, by the end of Elizabeth's reign, it had increased to almost 70%, with about a quarter of them being trained professional lawyers. Yet, this was, in itself, controversial. Robert Dudley, the first Earl of Leicester, was an important Privy Councillor and a favourite of Queen Elizabeth I. He loudly complained that too many common attorneys were being appointed JPs. He found it ridiculous, offensive, that the sons of butchers and merchants and carpenters were being appointed to the same office as gentlemen like himself. He did not see the office of JP as a legal office, despite it overseeing the local courts. He saw the office of JP as a social status symbol to be given to powerful, wealthy people like himself to prove their place in society. Now, we can look upon his criticisms with the healthy amount of arrogance for which they were spoken with, but he did have some legitimate points. From 1327, there was a minimum wealth requirement expected of JPs. You had to earn at least £20 a year, mainly from income from land, to be suitable. This was a considerable amount at the time, well over £1 million in today's money. This was because it was desired that JPs be local landowners, because it was assumed local landowners had more local knowledge. They had the wealth to be able to travel long distances, and they could hire servants. Furthermore, it was thought that their status as gentlemen gave them authority. Trained lawyers had few of these traits, even if they did have a law degree. However, Leicester's criticisms were mostly ignored, and lawyers became increasingly representative amongst JPs, especially as that minimum wealth requirement I mentioned of £20 a year, that did not change until the 1700s. But inflation devalued its value. By the end of Elizabeth's reign, £20 a year was worth a fifth of what it had been at the start of her reign, meaning many lawyers who were previously too poor to be appointed JPs were now suitable, and they were appointed in numbers. Yet, the controversy, the debate around whether a JP should have a law degree or even be educated at all was still up for debate. It's still debatable today. There are still disagreements. There are still people who will feel awkward about people with no law degree imposing criminal sentences. Thus, under Elizabeth I, in 1581, she advocated the use of William Lambarde's Ironarca. Ironarca was a guidebook. It was designed to be given to JPs to explain to them the powers and duties of their office and the appropriate punishments for a vast swathe of different crimes. It very much can be seen as the predecessor to the intensive training modern-day JPs undergo before they can impose criminal sentences. The author, William Lambarde, was a trained lawyer and a JP in Kent, and he wanted his Ironarca used because he knew that many JPs did lack the appropriate legal education, and that there simply were not enough trained lawyers to be able to deal with the increasing responsibilities of the office. We've seen, then, through this talk, that under Elizabeth, there were both many problems with the office of JP, but also many attempts at reforms. And while the office under Elizabeth did become clearly more professionalised than the amateurish office she inherited, with more JPs, more educated JPs, more lawyers to deal with the increasing responsibilities that they were given, and the use of William Lambarde's Ironarca, there were still many problems with the office. I asked you whether someone with a law degree should be able to impose a criminal sentence. That debate has been raging for centuries. Personally, historically at least, I agree with the local historian, Professor Alan Everett. He said that JPs were the most cost-effective and efficient form of local government in Europe. And while they've undergone many changes, and while that statement is very much in historical terms, I do believe it reflects why JPs, who play an important part in the legal process, have survived for centuries, whether or not they are formally educated. Thank you very much.